Ladies and gentlemen, this is Verity Seeker, and I'm your host, Mark Powls. I just finished today a small claims telephone hearing for a petition, a constitutional petition for the taxation of personal property on our land. I don't believe this has ever been done before, but I just finished the last local hearing. It'd be the third one. Two of those would have been with the county appraiser, and then this last one today was with an unbiased moderator from the Board of Tax Appeals and the county appraiser with me, of course, to go over what the protest was about. The thing is that, as I've described in this letter that I sent both parties prior to this hearing, it shows that there is a divide. There's like a wall of separation between the appraiser's office and the person who is trying to petition for a redress of grievance on a constitutional basis. Okay? So what I'm going to do is I'm going to go ahead and read the cover letter that I sent both parties prior to this hearing. And what I was trying to accomplish was to get away from the valuation compromise or negotiations and into the realm of a strictly constitutional petition on the taxation of our personal property and land, of course. So here it is. The subject, of course, this is a hearing. This is to the hearing officer and the county appraiser. So they would have all of my supporting documents prior to this hearing. And this is what I wrote. The subject, small claims telephone hearing, documents pertaining to evidence to petition for a redress of grievance pursuant to Section 3 of the Kansas Bill of Rights and by the authority and protections enumerated in Sections 2 and 20 of the Kansas Bill of Rights as listed in order of supremacy prior to any article that follows in the Kansas Constitution. To all parties involved, small claims telephone hearing. It is apparent to me, the taxpayer, that my petition for redress of grievance or my evidence pertaining to the gross constitutional and moral violations found in Article 11 of the Kansas Constitution will not be recognized in this telephone hearing. It is obvious to me that there is a wall separating the evidence we bring to the table, like comparing peanuts versus apples, but it must be done. It is historical fact that state governments operating as constitutional republics, as required by supreme law in a federal republic, must operate within the framework of a written constitution to limit government and protect the innate rights of the people as residents of Kansas. For example, constitutions are generally written and ratified in a sequence of superiority throughout its entirety, and any article that follows must be in pursuance to what precedes it. For example, when Kansas was chartered to become a state, sovereign, independent country, as a voluntary member of this united compact we call the United States of America, a union, its original ordinance stated as a decree describing a contract between the government and Kansas, and the people of the state, which states that this government shall possess the right to tax land as property to fund itself. The 5 short paragraphs in Article 11 at that time was more nearly pursuant to that order or decree in verbiage and procedural structure. By reading Article 11 in 1861, one must come to the conclusion that any taxation on our personal properties would be a violation of the right to own and control one's own property without infringement by others or their governments, even though you can find a hint that it was already being violated in a limited manner in 1861. Article 11 is a clear violation of the ordinance and Section 1 of the Kansas Bill of Rights and should be deemed an infringement upon the people of Kansas. My protest has nothing to do with the calculated valuation of our personal properties below or above the land we own, but rather the very act of appraising a property owner's home, commercial use buildings, barns, sheds, fences, or any other tangible personal properties below or above our land is a violation of what precedes Article 11 in the Kansas Constitution. Regardless whether or not Kansas voters were tricked into voting for equalization with and or a progressive taxing scheme on our personal properties such as our homes and other structures doesn't make it constitutional, especially if such an article in a constitution violates parts of the Kansas Constitution that precedes it. And it does at great detail. Article 11 is a massive violation to several of the Kansas Bill of Protected Rights, which comes before it, and blatantly contradicts a very specific ordinance which enumerates exactly what Kansas government possesses a right to tax to fund itself. Respectfully yours, Mark A. Powls. Okay, there you have it. I am going to do a documentary with all of the content that I've recorded from the very beginning of this process. I even have recorded video of a friend of mine who is a farmer who owns land and has barns and so on and so forth at the very first meeting as a protester with his appraiser here in Anderson County. So I'm going to have a lot of footage showing the process from the beginning to the end. And my goal and what I did achieve as an outcome in this final meeting at this level is that it is now in the constitutional realm, not the valuation legal realm. And the target is Article 11. So there you have it. The next stage will be an in-person formal hearing with the Board of Tax Appeals. And I'm looking forward to that. And again, I will have that recorded as well. And my hope is that I will be able to stand in front of the Kansas Supreme Court on a constitutional basis to focus everybody's attention on Article 11 as the root cause of the property tax issue. This is Verity Seeker. My name is Mark Powls, signing off.